Okay, this is Attorney Jennifer Rozdzielski with Carl Shusterman's office. Sorry about the little glitch there. I'm ready to get started in a few minutes. Basically, today we're going to be talking about winning your case in immigration court, just tips of the trade. I've handled thousands of cases in immigration court, and Mr. Shusterman's been doing this for 40 years. A few things before we begin. I'm basically going to talk and go through, the procedures and recommendations for the first part, and then I'll take any questions that there might be regarding that. One thing you want to keep in mind is this isn't, formal legal advice, so each case is different, so I can't give too many specifics about what I would recommend in a given case, so it's going to be generally broad. And also I recommend signing up for a newsletter. We have once a month a newsletter that gives new immigration tips as well as the news that's going on, any changes in the law. And also, if you want to schedule a consultation, it's very easy to do. You can schedule it online at our website, Shusterman.com. Okay, so I will wait 1 minute and then I'll get started. So one thing though, that before we start, there has been a lot of changes recently, obviously with the new administration. So that's been one thing that's really important going forward in court, because what was once the procedure before years ago is no longer going to make it a successful case. So to all my viewers out there, I guess I'll get going. So basically, when you go to immigration court, you're initially served with what's called a notice to appear. This is essentially your charging document, just like you would have in criminal court. If you got arrested for, say, a DUI, they're going to have a criminal complaint. So the notice to appear will lay out, the reasons that they find that you could be deported from the United States. Most people, it's generally they entered unlawfully. Others, they overstayed a visa perhaps, or it could be related to various other things. It could be criminal, fraud, a lot of issues. So that's the official document that'll put you into court. Once you are into court, there's the first thing that's going to happen is you're going to have what's called a master calendar hearing. Hello, Sonia. And, during this initial master hearing is basically just to go over that charging document. It's called the notice to appear. I would say in the vast majority of immigration cases, most people end up just admitting to the notice to appear and moving forward. Just because you're put into immigration court doesn't mean that you're going to get deported. Just like in criminal court, you have the opportunity to request relief or put up a defense against deportation. So even if you are, removable, there are options going forward. I see Roshan Ara has a question. How many times need to get a spouse visa? So, I'm really addressing immigration court in this dialogue. However, I am also well adversed in family immigration, which has a lot to do with immigration court. So one thing, what you can do in court as well as outside of court is apply for relief. And part of relief could be a family petition. So it could be your spouse, your child, your parent, or a sibling can petition you to get a green card. In particular, if a spouse petitions you, if they are a U.S. citizen, then you do not have to wait. So let's say you're in court and you are basically, removable because you came here on a visa and you overstayed. One option you could have is you could have your significant other, your spouse, petition you for a green card. Now, the process to get a petition is not in front of the court, it's with USCIS. And when you do that, it takes about 5 to 8 months for there to be a decision on that petition alone. So say you apply for that in immigration court, or whatever relief you apply in immigration court. After your first hearing, they're going to reset the case for probably 6 months or so for status on that. So if, say, you did the spousal petition route, after 6 months, you would come back and have the approval notice. Once you petition someone or once you apply for relief, the immigration judge would reset the case for a final trial. In the case of a spousal petition, the petition is the first step, depending on if your spouse is in the U.S., if you're in immigration court, if the spouse is abroad. There's different procedures on how you would actually get the green card from that step. And so the time could vary. If the spouse is in the U.S., it's going to take another 6 months to process the green card application, assuming there's no issues. If the spouse is abroad, you'd have to do the immigrant visa procedure with the National Visa Center, which is going to take you roughly the same time. If you're going through court, honestly, the courts are so backed up, it could take years. So that's one thing to be mindful of in immigration court is, even if you don't have many good options, the procedure itself will take 3 to 5 years. Just because the judges right now in Los Angeles, for example, have 50,000 cases. So for them to be able to handle that docket, it's impossible. So even with Trump and the new administration trying to push for these fast deportations, it's just not a realistic expectation. So going back, anyone that has joined in, again, I'm Jennifer Rozdzielski. I specialize in removal as well as family immigration. So it's one thing, to sort of, what do I want to say? When you're in immigration court, there's a lot of attorneys out there that have experience, and you want to make sure, though, that you pick someone that has a high success rate. So your attorney in immigration court is another thing that's really important. A lot of people need notarios who hook them up with attorneys. This is dangerous. They don't really have your best interests in mind. So going forward, after you get through the initial pleading stage and you're set for filing relief, one thing you want to do is make sure that you submit a lot of evidence with whatever application you're applying for. So like I mentioned, it could be something through a spouse. It could be a spousal petition. Or it could be something called cancellation of removal. That's eligible for people who have been here for 10 years and have good moral character and relatives who will experience extreme or unusual hardship if they are removed from the United States. Another option a lot of people apply for is asylum, withholding, and protection under Convention Against Torture. This is a hard application to win. But if you document, all your claims, then you have a much stronger chance. You can never really have enough evidence, is one thing that I always advocate. And after you apply for the relief, basically your case will be set for a final hearing date. This is called a merits date. This is the hearing that's similar to a criminal case. Similar to a criminal case, you'll have a whole trial. So you'll take direct testimony. There will be cross-examination. The judge could ask you questions at any given time. And you'll have an opportunity to present witnesses and expert testimony. Depending on what type of application you're applying for, that obviously details what kind of evidence you'll want to submit to what we say corroborate or support your claim. So if you're applying for a family-based application, you would want proof that your marriage is valid or that your significant other or family is going to experience hardship. So maybe medical bills, if there's a medical issue in the family or school-related issues, then we'll have those as well. If it's based off a spouse, you need joint documents and lots of photos. I always do tons of photos because that really can show the judge or the immigration adjudicator, the closeness of the family and give them an actual sense of a bond to you, not just a number. So you'd want to make sure that before the hearing, 15 days prior, you submit all this evidence. And then also it's important to prepare with an attorney and prepare your direct testimony, go over potential cross testimony as well. You'll want to have witnesses. If it's an asylum type of case, I highly recommend expert testimony and also articles supporting your claim that you're going to be persecuted or harmed in your country. So these are all things that you need to, even if you have an attorney, it's important that you take responsibility for your own case because it is your own life, and try to build the best case you can. The best way, I think, to win, regardless of who your judge is to support it with evidence and make it impossible for them not to approve you. So I have another comment. Then, how much do you have to pay? So each attorney, it varies how much in each case can vary too. Some removal attorneys are cheaper because they do more quantity over quality necessarily. I can't give specific quotes right now on what I would charge because I need to know the facts of the case, what stage in the process you're at, and all that. But feel free to either contact me by email or call our office if you have questions, more specific questions about costs. But it really varies from each case to case. If your case has been already filed, obviously there's going to be a smaller fee than someone who's starting from the beginning. So I can't really give specifics on fees, but feel free to call or contact us by email if you have more specific questions to that regard. When you get to the final stage, one thing that is important as well is what judge you have in immigration court. If I have a client and they come in and they have the best judge that you can have in Los Angeles, then of course I know right away we don't need to overkill it in certain areas. It's important to focus on what each judge looks at and what is important to them because they all have their different style, which goes to you really want to have some attorney represent you who has local knowledge of the judges. I can't downplay that enough. I've had people call me all over the country and I've advised them, don't necessarily go with me in this situation if that judge is very particular. Those relationships are important. So I have another person asking, can you file an I-131 for Dreamers? Okay, so this is going a little off topic, but in immigration court, people that have been under DACA, they had their proceedings terminated. Right now, we don't really know what's going on with DACA, although the litigation has forced USCIS to continue accepting applications. In fact, I submitted one today. But that being said, previously DACA holders could apply for advanced parole, which would be your form I-131. Right now, this administration has stopped doing that. So right now you can't. You could have filed, but it's going to be denied an I-131, and you're going to pay a fee on that. So unfortunately, right now we can't do that. It remains to be seen the future of DACA, although it's not too promising that legislation is going to be passed, but we'll see, hopefully. Going back, in case anyone recently joined, I'm Jennifer Rozdzielski. I'm an attorney with Carl Shusterman's office. I've represented thousands of cases in court, and I specialize in family and removal immigration, as well as various other things like waivers and other applications like that. So, specifically, I was trying to focus on court mostly today. With the change in administration just recently in January, they came out with a new protocol saying that the newly filed cases are going to have priority. So people that are now being put into court, no longer waiting 5+ years for a final hearing, they're going to be pushed to the front of the line. I predict this is going to realistically not work out, and it's going to create chaos because many judges already have their calendar set up until 2021. So now if they're supposed to push all those cases back, some cases might be sitting on the docket for 7 years. But these are all strategies in your case. For some people, if you don't have good options to get the green card, buying time is the best option because something new you could get married, or a new legislation could pass or something could happen. And this would open up a new opportunity. I've had so many cases where we lose at immigration court, go up to appeal, the law changes, you get sent back to court, and they get the green card. So time is usually on your side with that. But, you know, like I said, with the new administration, we'll have to see. Okay, sorry, I'm having, let's see. Should have done. Okay, hi, Tony. I think you should adopt me. Okay, I'll let Carl know that you're interested in that. So, I mean, this is the basic procedure in immigration court. Of course, you know, you want to win your case. In the event you don't win your case, there's always the appeal process, and that can take a long time. The Board of Immigration Appeals is where your first appeal goes. That takes roughly 6 months for a decision. It used to take longer, but again, with the new administration, they're going much faster than before. After the first appeal, say you lose that, you could appeal again to the circuit court in your jurisdiction, wherever that might be. Here in the Ninth Circuit, you know, it takes at least a year after that for your appeal. So, you know, you're still, even if an immigration judge denies you or orders you deported, you're rarely being physically deported. You know, you get a stay during the appeal process, you get to continue with your work permit. And so let's see, so I guess I can start taking some questions. I have been taking some, but, you know, I'll open it up more to questions because that's a basic procedure. Again, like I said, a lot of it is depending on what evidence you submit. You need to support your case. It's your life. And even if you have the best lawyer, you need to make sure that your lawyer files the paperwork and is advocating for your case. You have to take the reins. So I'll answer a few questions. Let's see. Brenda Rodriguez asks, if I haven't legally changed my last name, does that affect me? I'm petitioning for my husband and have to write a waiver and provide supporting documents. So again, I can't give I can't give legal advice specifically to your case because I don't know, you know, for example, I don't know why you need a waiver, if it's a criminal matter or fraud matter, I don't know which section that's under, but as long as you're legally married, it doesn't matter if you have a different name. A lot of people nowadays get married and don't change, you know, women aren't changing their name to their husband's name now. It doesn't change the fact that you're legally married as long as the marriage is what we say bona fide or real. So I have another question coming in. I'm sorry, I don't think I'll butcher your name, from Chandra Mali. I hope I'm right on that. So you're asking, what is going to happen to people from countries where TPS like Haiti was removed? Great question. So TPS, which is temporary protected status, was granted to several countries. For example, like you said, Haiti was one, Nicaragua has been one, El Salvador, and these people have had protected status for a significant period of time, many years. Basically, temporary protected status is just, you can work here and live here, you don't have a green card, but we're not going to deport you. And often they could also receive advanced parole to travel. So if that's removed, obviously they're not getting the work permit anymore. They're not going to be able to travel anymore. And certainly the administration could put them into immigration court. And then they'd have to apply for some other option for relief. Of course, you know, it's really difficult because many of these people have assimilated, have been here 20 years and, you know, are otherwise wonderful people. So that's going to be, you know, it's a sad reality. So technically they should, when it ends, they're supposed to go back, but a lot of people obviously won't. And if they're put into court, they're going to have to apply for different options. And one of those options could possibly be cancellation of removal, which I discussed a little earlier. Again, that's something where if you've been here 10 years and you have a qualifying relative, which would be either a spouse, parent, or child under 21, is going to experience extreme or unusual hardship if you are deported. So that might be a viable option if people with TPS are put into court. Also, I don't know if they potentially could do a family petition. Maybe they're married to someone, and while they had TPS, they went out on advanced parole and re-entered the United States. Then they could apply for adjustment. And here in the Ninth Circuit and the Sixth Circuit as well, if you have TPS, that is considered an admission, meaning even if you came here unlawfully to begin with, you could do a family petition based off having received that TPS. So hopefully, there's going to be options for those people, but it remains unclear that, basically they're going to be supposed to leave when it ends, unfortunately. And that goes really for the DACA as well, or any of these protections that were put in place previously. Trump's been getting rid of all of those. So I imagine they're going to put more people in court. And one thing with that, though, is like I said, the court's already backed up in Los Angeles, 50,000 cases and only 20 plus, maybe 30 judges. So they're backed up years and years and years. Trump might not even be in office by the time a lot of these cases would even get tried. So it's we'll have to wait and see, but it should be interesting times. It just literally, they don't have the manpower to deport as many people as he campaigned. So like I said, I'll just go over once again the key points to winning your case. Obviously, you want to have legal representation. I've picked up cases where they didn't have a lawyer, even if you are well-read and you understand your rights and everything. The prosecutors, what we call them, trial attorneys, they could take advantage of you. I've seen judges where people clearly could have applied for a green card and qualified for some option, and it's not their duty. It's not their responsibility to tell you, hey, here's an application, you qualify. So you need to have legal representation. The second thing is documenting your case. There's never enough evidence. I mean, I've had judges literally tell me, why are you submitting 1,000 pages? And that's because it's our burden. So you want to make sure you document your case, and then also bring witnesses. If it calls for it, have an expert witness. Those really can paint a case for a judge and have them understand country conditions or hardship. Let's see, I have another question coming in from Mary. The Visa Bulletin F4, what is the difference between final action versus the date of filing things? So you always want to go by the dates for filing family-sponsored visa applications. The final action dates, they're rarely used. So it's never going to apply to you. So you want to go for the dates for filing the family-sponsored visa applications. So yeah, that's not really an immigration court, but like I said, we do handle all types of cases. So I do family, immigrant visas, we do consulate processing, I do waivers. Our office pretty much has someone for everything. We have an employment-based EB-5s, extraordinary abilities, do DACAs, a lot of U visas. There's a lot of options out there. And a lot of these you can apply for outside of court, but in court it's a different scenario once you get there. So my best advice though is making sure you document your case. Especially if you do lose, because when you go on appeal, you need to prove that the judge overlooked that evidence. And also get an experienced attorney. Please sign up for our newsletter, and every month we have a monthly newsletter, provides you new updates on immigration, also cases that we've won that maybe they have similar fact patterns to you, so you can get an idea. And if there's not any more questions, I'm going to be signing off now. Okay, so thank you everyone for tuning in, and we will be doing this again next Friday. It will be with Giselle Sotelo. She's going to do the Spanish version, And let me know, or you can always email us. Let us know if there's any particular topics that are of interest to you, or that you would like to ask any specific questions. Like I said, we can't really give exact, it's not, I can't really give you legal advice specific to your case without seeing the documents, without, having a one-on-one conversation. But general broad questions, I can, we can try and address. And okay, there's another question from Brenda. So we will eventually have to go to Juarez. Okay, Brenda, so you're probably doing a 601A. One thing that Obama did was in 2013, he made provisional waivers, meaning if you came here unlawfully, you used to have to go back to your country and wait a year to apply for a waiver for your previous unlawful presence before you could get a green card. Now you can apply here in the U.S., and once the waiver is approved, your case gets sent to the consulate for an interview. Yeah, I've done so many of these. They can be pretty good cases. If you go to Juarez, so basically, if after the I-130 is approved, which is 5 to 8 months, you have to apply for the waiver. The waivers they're getting back between the same time period, but actually more like 6 months. So after the waiver is approved, then the case is sent to the MVC, the National Visa Center, where they process the fees and all the paperwork, and then you're looking at probably 4 months before an actual interview in wherever your consulate is for you, Juarez. Once you're in Juarez, you have to get there probably 2-3 days before the interview, and then it's going to take another week after that to get the actual visa packet delivered. So overall, the process you're looking at a little more than not quite a year and a half if you have someone competent doing it. So I hope that's helpful. So again, if you have any questions or concerns, feel free to give us a call or email us, or if you have any more ideas of things that you would like us to talk about. And thank you for attending this. It's our first live broadcast. We hope to make it every Friday. Again, we will have one next Friday in Spanish, which is El Sotelo. So thank you, Facebook, and it was nice talking to you.